So there's three grounds on which we're seeking dismissal of this case. I filed my motion to dismiss. I don't know if you've had a chance to read that, Judge. But okay, so the first ground is that this court lacks jurisdiction. Second, this matter has already been litigated and adjudicated twice in California. And third, my client was never properly served with a copy of the petition in this case. On the jurisdiction issue, this court lacks jurisdiction over my client and this matter because the Family Violence Act provides jurisdiction over non-residents only where the acts of family violence are alleged to have occurred in Georgia, and that's OCGA 1913-2B. My client is not a resident of Georgia. He has never been a resident of Georgia, and the petitioner has not alleged that any acts of family violence occurred in Georgia. The basis of petitioner's complaint is an alleged incident that occurred in California on February 6th. Petitioner alleges that the party's 6-year-old son returned from parenting time with his father, my client, with a bloody knot on his head. Setting aside for the moment the fact that petitioner has no evidence that my client had anything to do with the scratch on the child's head, it is undisputed that both parties and the child were in California when this incident occurred. That alone dispenses with petitioner's claim relating to the child. This court cannot issue a protective order on behalf of the child based on these allegations because this alleged incident did not occur in Georgia. Therefore, this court does not have jurisdiction as to that claim against my non-resident client. The only other allegation of family violence that the petitioner raises in her complaint is that my client allegedly threatened her life, quote, if you leave California. Again, there's no evidence that my client ever made such a threat because he didn't. But again, you don't need to decide that question, Judge. You only need to determine the threshold question of whether such a threat would constitute an act of family violence that occurred in Georgia. And under both the Anderson and Huggins cases that are cited in our motion to dismiss, it's clear that a communication sent from another state, whether by phone or by email, does not constitute an act of family violence in Georgia. The act of placing the call or sending the email are deemed to have occurred in the state where the communication was sent. And petitioner does not allege that my client came to Georgia to make these alleged threats against her. She doesn't even allege that she was in Georgia when the threats were made, allegedly made. She claims that my client threatened her if she left California. But even if she were in Georgia, the alleged act itself did not occur here, and the court does not have jurisdiction to enter a protective order based on this allegation. So petitioner's complaint should be dismissed for lack of jurisdiction as to both the claim she made on behalf of the child and the claim she made on her own behalf.
Let me make this abundantly clear. She used a scratch the child got as an excuse to allege family violence, and when she got shut down for how ridiculous of an allegation it was, she then moved all the way to Georgia with his kid after he got full custody, and she stopped receiving alimony after what? She tried to pull.
The second ground on which we're seeking dismissal is that this matter has already been litigated and adjudicated in California. Petitioner filed a request for domestic violence restraining order in Los Angeles County on February 9th based on the same allegations regarding the child having a scratch on his head on February 6th. The Los Angeles court, where an ongoing custody case between the parties is currently pending, held a 2-day hearing on February 17th and 18th, and then dismissed petitioner's request for a restraining order, finding that she had not met her burden of proving her claims, the same claims that she's making here today. Undeterred by her case being dismissed, petitioner refiled her request for a domestic restraining order in Sacramento County on March 9th. And again, alleging that the child returned from his father's house with a bloody knot on his head on February 6th. Again, this matter was heard over the course of 2 days on March 30th by the Sacramento court, which found that it was not the proper.
So, Ms. Holmes, when she argues, we'll let you respond. So if you're taking notes,
because that's not true.
Okay, so what she's doing is making an argument, it's a motion. So this is just her. So it's not testimony on her behalf. She's just making an argument. So what she finishes, I see you're taking notes, then you can respond to her motion. How about that?
Yes, Your Honor, I'm sorry.
Okay, yeah, no, it's okay. Go ahead, Ms. Simpson.
So this matter was heard over the course of 2 days on March 24th and 30th by the Sacramento court, which found that it was not the proper venue to hear the petitioner's claims given the pending custody case in Los Angeles. Petitioner now brings her claim for the third time, again in an improper venue. And because this case has already been decided on the merits by the Los Angeles court, and the Sacramento court has confirmed that Los Angeles was the proper forum to make that decision, Res judicata and judicial estoppel bar this court from retrying this matter and second-guessing those decisions. So therefore, petitioner's claim must be dismissed. Finally, this case should be dismissed because my client has never been served with a copy of petitioner's petition. She failed to serve it on him. She only served him with a copy of the ex parte order. He has been able to obtain a copy from the court, but service has not been perfected, and the court cannot enter a 12-month protective order without service. Now, we obviously want to be heard on our motion to dismiss, but we're not waiving the defense of lack of service. So in closing, I just want to note the real reason that we're here, if it's not already obvious. Petitioner is desperately seeking a way around the custody orders issued by the Los Angeles court. The custody case in Los Angeles is not going her way, and she is abusing the court system in an effort to get her way. Petitioner has been ordered not to remove the child from California while the custody case is pending. And now that her alimony has run out, she wants to move with the child to Georgia, and the Los Angeles court has denied her request to do so. So she's looking for a way around that. A psychologist has been appointed as the custody evaluator in the Los Angeles case, and he's been conducting an investigation. The case will be going to final trial there later this year. But petitioner doesn't want to wait for that trial. She's already absconded to Georgia with the child multiple times. She's forum shopping, trying to find a court that will let her circumvent the orders of the Los Angeles court. And this is important. The most recent order from the Los Angeles court, the same court that heard and denied petitioner's first request for a TPO, that order awards my client sole physical and sole legal custody of the child. Petitioner is awarded supervised visitation. Petitioner was ordered to deliver the child to my client on April 22nd at the Sacramento Police Department, and the order provides that if she fails to deliver the child, the Los Angeles District Attorney Child Abduction Unit is appointed to locate the whereabouts of the child, take possession of the child, and deliver the child back to my client. Petitioner failed to deliver the child on April 22nd. Instead, she went on the lam with the child and 3 days later filed her petition in this case.
She's obviously misusing the court system because they won't do her bidding. But since she knows she most likely will only get a slap on the wrist for it, she feels comfortable kidnapping his son and taking him across the country to avoid the order that awards him sole custody. If the roles were reversed and the father was the one who did that to her, I have a very strong feeling he would be in jail by now.
So she and the child are currently in hiding. She has been withholding the child from my client since February 23rd, despite the valid court order granting my client sole legal and physical custody. He's not been able to see his son in over 2 months. So we're asking this court to issue an order domesticating the April 22nd California order, a certified copy of which was filed along with our motion to dismiss, so that my client can work with law enforcement here to retrieve his son. And so more court and law enforcement resources will have to be devoted to this, all because petitioner wants to keep the party's child away from his father and is trying to pit one court against another so that she can get away with that. We're asking that her case be dismissed and that petitioner be ordered to pay all of the attorney's fees that my client has been forced to incur in defending against petitioner's latest attempt to evade the California court orders. And we're asking for those under both 1913-4A10 and 915-14.
Ms. Holmes, now it's your turn to respond to her motion. Okay, so this isn't you making your case. This is you responding to her motion of the orders in California and things like that. Go ahead.
Yes. And I will also attach the additional evidence. First, I wanted to say that the things that she is saying is definitely hearsay. I have spoken to all law enforcement in Sacramento. I have spoken to the child abduction unit in Los Angeles. I would like to start by saying I would never relitigate the same issue. The violence that happened on February 6th, when I immediately came here, my ex-husband has manic issues of violence. He is known to be violent. And I have a history of him being violent. On February 6th, when he harmed our son, I told the Sacramento police that we were fearful because he has broken into my house and abused me before. I said that we were fearful, and that's also provided in the police report from even 2017 that I sent in evidence. The police told me that it was okay. That
Objections to hearsay, Your Honor.
Okay. But I can't hear
I have a police report. And
Okay, but
so
hold on,
I would object to
hold
that.
on, hold on. Okay, so so what you need to respond to is like her motion. It's
okay,
not it's not testimony about anything that's happened, so I can't hear
Okay.
anything else anybody else said.
okay. So when we were transferred, we came from California to Georgia on the 6th, and then we're made to come back. DFAX was even contacted. He contacted me and told me if I didn't return back to California, he was going to find a way to take RJ and have somebody harm me. We came back and then we litigated there. Los Angeles County does not have jurisdiction over the original violence or any at all, because he doesn't live in Los Angeles County. The only person that is forum shopping to make sure that the violence is heard in a venue that is beneficial to them is Rashawn Holmes. He is an athlete that feels like he is above the law and can get his way. He is on record violating orders. We have final orders that we fought for. The person that is making these
Not only is she making up stories of violence in a desperate attempt to get a ruling in her favor, but she just accused him of doing everything she is currently doing. Like I said before, if this was a man doing this, he wouldn't have even gotten this far to begin with. But they've let her get away with false testimony, forum shopping, disobeying court orders, kidnapping his son, and taking his son across the country.
orders for, as far as the orders for April 22nd, those orders were made after he already threatened to call the child abduction unit in Los Angeles, and I called them first. Rashawn does not live in Los Angeles and never has had a lease in Los Angeles. I used to live in Los Angeles. I've been a resident of Georgia since November. The person that made those orders is a private mediator that gets paid $2,000 an hour by my ex-husband. He is a mediator to the stars, and he is known for giving rich men their way. Rashawn lied to the Sacramento court. When I did do the domestic violence restraining order on March 9th, I contacted the district attorney's office before I even did so, because and her saying that he hasn't seen Rashawn and RJ in 2 months is not true, because after the 6th, I complied and let RJ go again from the 20th to the 23rd of February. So he returned again after the abuse that happened on February 6th. And when he returned back to me, he said that he was still afraid to go and that his father—
Objection to hearsay.
Yeah,
no, we have CPS workers.
I can't hear what they said. You just have to state factual thing.
Okay, factual things is that my son came home and said that he was—
Objection to anything that the child said.
Yeah.
Okay.
So it's like, so what she's talking about are court orders. You know,
Okay, so and the court order from March 9th was made after there was more alleged violence based on the things that was said to me by my child. I then took that information to the proper venue. The police in Sacramento told me that—
Objection to hearsay.
all right. So I can't hear what the police said.
Okay, yes, but I was under the belief that I had jurisdiction in Sacramento, and so did the judge on March 9th for the additional violence that took place. And they issued me a restraining order. This motion to dismiss is what he always does, because he has the money to get a lawyer and submit anything into the court. He tried to motion to dismiss the March 9th DVRO 3 times, and the judge— exactly what we're doing now, and the judge dismissed it. When we did finally go to court on March 30th for extending the DVRO, he lied and told the Sacramento, California court, which is in our orders, that he does not live in Sacramento, even though that's where he currently is and that's where he was served. So forum shopping, in order to get the forum in your proper, where you want it to be heard, you lied to the court and told them that you did not live in Sacramento, and you do.
And so don't talk to him.
I'm sorry.
That's okay.
And in order to— 1 second.
It sounds like she is upset. He didn't just roll over and let her have her way. For those who don't recognize him, he is an NBA player for the Sacramento Kings. So if we put 2 and 2 together, it is no secret what she's really after here, which is his money. Yet since she lost alimony, her only option is to get the kid by any means necessary to get child support. But her plan has backfired miserably as he gained full custody per the previous court orders.
Okay.
So in an effort to continue to get his way, I'm sorry, I had to move around. So my son was. In an effort to get his way, he is doing the same thing that he did in Sacramento because he just doesn't want the violence to be heard. So after March 30th, he was him and his family began attacking me in media, and we were told that it is totally okay for us to go back to our home in Georgia. We were only there on visitation purposes. After March 30th, after he lied and told the judge that he did not live in Los Angeles, we spoke to the California domestic violence advocate for the Secretary of State, and I filled out a good cause notification, and I filled out a safe at home program with which is a domestic violence program in California, in order to make sure that I lawfully came back to my home in Georgia. We were in domestic violence shelter from March 30th. I even gave him the opportunity to meet with RJ, with a mediator, to speak about the things that RJ was saying about what happened to him. He refused. He is only interested in controlling me, controlling RJ, and controlling the situation. Also, the violence has taken place here. A DFACS worker came to speak to RJ separately, and this is about my 6-year-old saying that he is afraid. And if that wasn't the situation, then the DFACS worker wouldn't have issued us a safety plan. Also, the police, the Sandy Springs police and the Fulton County police were contacted. I showed them those orders, and the orders from a private mediator that is privately paid on a fiduciary in a fiduciary fashion by one party. Those are not orders by a superior court judge. That is not a superior court judge. I complained to the commissions on judicial performance, and I filled out a appellate and a motion to dissolve the stipulation. What we're in is a mediated stipulation by a hired neutral who is not supposed to be making changes to our stipulation, as you see from the letter that I received from the judicial commissions of performance. He is not a judge. He is not a member of the bench, and he is not a member. And the orders that he creates are paid orders by $2,000 an hour. The stipulation, that is the only thing that the evidence that I wasn't able to provide. This, and he is blatantly, if I've done something wrong, it's because I'm just trying to protect our son, who says that he's afraid of you. He is actively lying in order to, I'm sorry. He is actively and purposely forum shopping in order to get out of each court. He lied to the Sacramento court to say, oh, I don't live here. And now here he is saying, oh, a superior court judge. If I called the Los Angeles court, and they know nothing about these orders. This is a mediator that is a mediator to the stars. He gets paid hourly by my ex-husband in order to give his way. If he stops giving his the mediator that made these orders about abduction, and this mediator has also done all different types of unlawful practices in order to give my ex-husband his way, because he is a rich athlete that feels like everything is supposed to go their way. I have been in compliance with everything. We have been divorced since 2019. I have been in compliance with everything that lawfully that I was supposed to do. I would never do anything unlawful.
Are you serious?
Because I don't even have the millions of dollars to fight in court. He does. what I'm saying is true and provable down to each letter with a piece of evidence. I wasn't able to provide all the evidence this morning. I was planning on doing all of that before the 13th, but to say that the violence didn't happen in Georgia, it absolutely has. He and his family members are on a line actively threatening me, showing guns, and I have text messages of him threatening my life the day that I served him.
Stop the cap.
And he was served to the best of my ability. I served the document that I received after our hearing on Monday. I also checked with domestic violence advocacy here just to make sure that what I'm doing cannot be considered forum shopping, because that's not something that I would ever want to do. He is the one that now provided evidence saying that this Superior Court judge ordered, the Los Angeles Superior Court knows nothing about the orders that the mediator Thomas Trent Lewis has issued. Thomas Trent Lewis is not a member of the bench, and the orders that he has created, he is a neutral hired by a law firm.
So this says that Judge Lewis is retired.
He is retired. He's not a judge.
Well, so I mean, you can tell by my accent, I'm not a California lawyer and don't think I practice law in California. Wouldn't even try to practice law in California. But I will tell you that there are retired judges and senior judges here in Georgia that would take some offense to saying that they're not real judges. So,
oh no, I'm just I apologize, Judge. Definitely.
No, I'm just saying. So this.
I'm speaking in terms of this case. He is not. I'm sure he spent time on the bench. He is a retired judge.
Well, that's what I'm saying. And it looks like. So let me kind of get you back on track. All right, if you don't mind, Ms. Simpson.
Please.
Okay. So it looks like these are orders that are signed. That have been submitted. Findings after a hearing, federal custody support. They're orders that has his electronic signature, and it looks like they were sent to a couple different lawyers.
Yes.
One of these lawyers, yours. So it was on one's January the 3rd. There's another one that was April the 22nd. So tell me, what is it that you have to say about the April the 22nd? Because the way I'm reading this, you correct me if I'm wrong. Because, like I said, I like to tell people, I know when I open my mouth,
no,
you gotta keep your camera on, Mr. Holmes. Hold on, wait on Mr. Holmes, because we don't know if he's there, and he's got to keep his camera on. Because this is akin to walking out of my courtroom when you turn your camera off.
Your Honor, I don't know what's going on with my camera. I'm still here.
Did you get a phone call? Sometimes you got to. You got to like?
No, ma'am. I went on mute and the video cut off, and I'm hitting to start the video now, and it's not starting.
All right. Does it do that if I say ask to start video? There you go.
Okay.
All right.
Thank you, ma'am.
Yeah, no, sir. That's fine. So I'm looking at this April 22nd order. Okay. Are you familiar with it?
Yes.
Okay. So it was electronically signed by Judge Lewis on April 22nd. And in here, okay, so this is where I'm kind of having some, because I can call out, I don't know what time it is out there, but I can call out there. It says, let's see, I want to make sure if you got it in your hand, let's see, okay, there's a case number. You're the petitioner. Mr. Holmes is the respondent, or plaintiff and defendant. So it says, respondent shall select 3 professionals and monitors to provide said names to you. You shall then choose 3 of those professionals and monitors as you may use for your visitation. So it looks like at some point, you're supposed to have supervised visits and pay supervisors. Right? I'm sorry, he's going to pay supervisors. So this was on the 22nd.
Yes, and that was
so this was, and it's signed by Judge Lewis. Okay, so hold on, back up. Listen, go back. Sorry, these are all scanned in. Let me get back to. Oh, there it is. Okay, it's marked. All right. So findings after a hearing. There was a hearing. The hearing proceeded at April the Can we share my screen so you can see where I'm at?
No, I can see. I know what you're
Okay.
referring to.
So it says it was April the 21st at 8 a.m. Good for Judge Lewis. Getting up there. I like it. All right. So 8 a.m. Let's see. Ms. O'Brien appeared at 8 a.m. on behalf of you. Filed the substitution of counsel because you said you wanted to, I guess that's pro se, but pro per. So you wanted to represent yourself. So there's modification, custody and parenting time. Here it said that sole legal and sole physical custody was awarded to Mr. Holmes.
Yes. And after I contacted the family, the Stanley Moss Family Court in Los Angeles, and also contacted the district attorney's office in Los Angeles, orders that are made by a private mediator fiduciary, he cannot change our final orders. They're supposed to be a neutral, and he does not have.
This is a court order. So I mean, like I said, I wasn't there. It says this is a court order. So there was a hearing,
and that was made, and it's because and mind you, the defendant does pay Judge Lewis, and the night before that happened, I made them aware that we were in a domestic violence shelter and how we were being treated was unfair, and I will be alerting the presiding judge that presides over this stipulation, because everything that is put in our stipulation, and if there are changes made, is supposed to go through the actual Stanley Moss Family Court. When we have Zoom court, they're similar to meetings. So when that was his attempt to, the night before, I emailed them and told them that we were in a domestic violence shelter, and that I was still being threatened, because of course the defendant is not going to say what he's been doing, and it even down to the violence that took place with our son.
Let me see what's so. I don't know what kind of athlete he is. I don't care.
But
really
that was his attempt.
Look here, I don't care. Famous, I'm famous. I'm a big deal. In Atlanta, I'm a big deal. Okay? So he ain't a big deal. Ain't nobody out here a big deal but me. I'm kind of a big deal. All right?
Yes.
And once, I guess he's hold on. He's probably tall, so he probably plays basketball. And I'm not impressed with that. I'll tell you why I'm not impressed with that, because I have played basketball longer than LeBron James, but it doesn't mean he's better than me. Okay? So bring LeBron out here and I'll whip him too. And I played basketball longer than him, so don't mean he's better than me. Okay, so all that athlete stuff, I don't care.
And I'm glad you said that, Your Honor, because honestly, we can't act like that aspect doesn't exist, because that is one of the reasons why I'm getting threatened, and that's one of the reasons why he wants to stay in private court, because once the violence.
So I don't care. So don't worry about talking about money. I don't care. I don't care about that. I don't care who he is, and I'll meet you on the basketball court, Mr. Holmes. I'll tell you, but I'm just telling you. Okay, that's it. So I don't care about what I care about. These allegations of violence, and like Ms. Simpson had brought up, when has Mr. Holmes been to Georgia and commit? Because here's the thing, something has to have happened in Georgia. So when's Mr. Holmes been to Georgia and been to Georgia and committed acts of violence?
Yes, and what I'm going off of for that is I look to see, does he have ties in Georgia? Does he work here? And did the violence happen in Georgia? He absolutely has threatened me. I've received the threatening here.
But has he been to Georgia to threaten you?
And he also put a tracking device in RJ's bag that we had to get rid of. And RJ's he gave him an iPad, and he was tracking our every move, which is how he knew exactly where we were February 6th. So the violence and when
you were in court on April the 21st, you were there, right? Yeah, were you there?
Yes, ma'am.
Okay, so you heard this judge say all this, right?
Yes. But
right.
I knew that it was based on the judge. That mediator and private judge and Rashawn are friends. He pays the bill. And when I emailed to the night before that court expressing that I believe that, you know, the judge just wanted to, or the mediator, it's his job to give Rashawn his way, because he's the one that's footing the bill. And Rashawn is just actively trying to save face, because now the private court is how he can keep his history of abuse quiet. Once things came to public in Sacramento, that's when he began, things were in the media, and the threats came harder, and he was upset. He is trying to keep things in the private specter, which only happens in California, New York, and Nevada, where you can even have a private mediator make changes to your stipulation. But that's what he's trying to do, because he wants to protect his brand. He wants to protect things like that. He doesn't want things to be able to be seen in the public specter of the court. But if there is allegations of abuse, it should not be covered up by any private court process.
She's basically saying, if I accuse him of DV, then the media should drag his reputation so he can lose everything he's worked for. This entire time, she's been repeating DV over and over, like that makes her made-up story any more believable. If he was truly so violent, why doesn't she have any actual evidence, like videos showcasing it?
I'm just trying to get you back focused on what has happened in Georgia. Is there anything specific that he has done here? Did he come here and sit outside of your house? Did he come here and follow you around? Did he come here and stand in your front yard and scream at you? Did he come here trying to track you down?